Good afternoon. Welcome to the Carpenter Law Firm studios. Today we're talking about vendor disputes, how to manage them, perhaps how to avoid them. That's the goal, of course. And we start with a quick reminder that the legislature is still in session. Are we safe when the legislature is in session? A quick idea here. At noon on July 15th, I will be doing a legislative update, changes in the law update, if you will, a legislative update. One thing has happened, and that is that the governor has already signed one bill. I find this bill to be particularly frustrating. Here's what it says. It's one sentence added to the Condominium Act and to the Planned Community Statutes. And I've highlighted and read a few of the phrases and words that bother me oh so much. If a board records a meeting that is open to the members, this could be the annual meeting, any meeting of the members, annual meeting, which we call the regular members meeting. It happens regularly once a year, but we could have a special members meeting between the annual meeting or a board meeting. If the board records the meeting, the board shall, I like the word must when we're trying to understand what shall means. The board must keep a copy of the recording for at least 6 months and make the unedited recording available to any member on request in compliance with section 33-1258 subsection A. And 33-1804, that's the Planned Community Statute. So we have this new statute that says if a board records the meeting. Now here's where I start to lose containment a bit. And I'm not some ranting and raving lunatic, but when I say lose containment, what I mean is I get a little frustrated. Does the board record the meeting? I've been to a lot of meetings in my career, and here's what I see. I see Bob, the secretary, get out a recorder from his personal belongings. I have a black leather briefcase that I bring with me everywhere I go. Bob's got a backpack. Bob's the secretary. Bob's going to endeavor to take the minutes. Bob's elderly and perhaps doesn't hear so well. It could be Sally, the secretary. But Bob or Sally could be 25 years old, could be 30. They could endeavor to record for any number of reasons. But the recorder is a personal belonging of Bob or Sally, the secretary. And they take this device and they plop it out of their personal belongings and set it on the table to record the meeting. It's their personal device. It's not in the possession of the association. I prefer the word association. I have a corporate client. The board is not recording the meeting. The board did not make a decision to record the meeting. Bob did. Sally did. And the device does not belong to the association. Dare I say, who owns the data file? When that recording is completed on that device, not owned by the association, Bob finishes the recording, finishes the minutes. What does Bob do? Bob deletes it from his personal device. Phone, cassette tape player with a hit record and play at the same time to record like we used to from the radio back in the day. The board must keep a copy of the recording for at least 6 months. Now, what's the awareness going to be of this statute to our far-flung associations in our 15 counties in Arizona? I don't know. When I visit clients in Yuma or Lake Havasu City, where this is a common practice. I don't know. So I've got problems with the words that begin the sentence. If a board records, the board's not making the decision to record. Bob is from a personal device. The board then must keep a copy of the recording. So now essentially we have a situation where the board has to say, hey, Bob, you recorded, hand over a copy. It's not on a cassette tape. It's on a digital file on the phone or whatever. And now the board has to retain it for 6 months just because Bob recorded it or Sally, the secretary, recorded it, and has to have the unedited recording available for 6 months. And then my final problem is this word on request, on demand. Now, many of you work for professional management companies. Maybe this isn't a problem. Well, maybe it is a problem at 3 o'clock on a Friday afternoon. That's my problem. 3 o'clock on a Friday afternoon. What does that mean on request? On demand, on request? Do we get to wait until Monday morning at 10 a.m. or Monday afternoon at 4 p.m.? I don't know. So these are the things we're going to discuss on July 15th and whatever else the governor signs between now and then. And hopefully the legislature will have adjourned by then. On average, over the last 3 to 4 years, the legislature adjourns between June 15th and June 30th of each calendar year. We'll see what happens. So I just wanted to highlight that. More to come, but not a careful choice of words here. And essentially, if you were wondering, where does this stuff come from? You listen to the recording of the committee testimony on this bill, Senate Bill 1039. Of course, there's a guy who wanted a copy of the recording and couldn't get it. So he was irritated. So he said, well, there ought to be a law. So he went to his legislator, and this is what we end up with. Now, you might say, well, if there's a Zoom meeting, just like this webinar that you're attending right now, it's easy for there to be a recording. And if you were listening when I started, this meeting is being recorded. It'll be up on my website. Well, that's easy. If the board is recording the meeting on purpose and the data file is being stored in the cloud, just like mine is, of this webinar, it's easy to keep it for 6 months and to make the recording available to anybody who asks for it. Now, I don't like on request, on demand, whatever that means. It says on request. This is verbatim. What's on the screen is verbatim from the bill, which will become the statute. So we end up in this weird situation where the legislature understands Zoom and automatic recording to the cloud if there's an intentional act of recording the whole meeting. But as you saw from my example, I'm worried about the intentional recording by a director who does it for some purpose to keep accurate minutes, where the board didn't make the decision intentionally or volitionally. But we tend to see these things through the eyes of board intention or professional management intention. But that's not always the case. I see the world through the eyes of exception and self-management or volunteer management, where the board members do all the work. Yet at the legislature, because of good lobbying perhaps and typicality, these things tend to be viewed through the eyes of professional management instead of the statistically significant number of associations where they're volunteer managed or self-managed. All right. You tuned in today for vendor disputes. Let's dive in. Well, let's start with the end of how we view vendor disputes. And by that, I mean, let's assume there's a lawsuit from a vendor. How does that happen? Well, let's assume there's a failure to pay the vendor, and maybe it's on purpose. I've seen this happen many times where a vendor has put itself in a position where there's a failure to perform, or the board perceives that there's a failure to perform. And so the board makes the decision, we ain't paying for that. Um, the vendor has screwed up. The landscaping looks terrible. The paint job is substandard. That's the vendor, the paint vendor, the landscape vendor. We're not paying for that. So there's a lawsuit from the vendor back against the association for full payment of the invoices. That's the lawsuit scenario here. We're starting with the end of a vendor dispute, not how we got there. Let's start with the end. Assume a lawsuit from the vendor for payment of invoices where the association has said, we're not paying for that. So the association's been sued. What are our defenses? Is our defense bad quality? Or is it failure to perform to the contract specifications? Well, it might be both. It might be, hey, the contract says that you're going to install decomposed granite. It may be that you were supposed to mow every week. You haven't mowed in 3 months. It could be any number of those things, fill in the blank. But it may be inadequate quality. It may be failure to perform to the specifications. But when there's a lawsuit, the first thing we do, and when I say we, I mean everybody, professional management, lawyers, whatever an association is sued, the first thing we do in every situation is we say, should we tender this to the insurance companies for coverage or not? And what we say as lawyers, all of us in the community association bar, that is the group of us that represent community associations, that's been my habit for years to say, let's don't prejudge or assume whether there's coverage or not. Tender to the carriers. Let the carriers say there's no coverage. Well, let's don't make any assumptions. Let's don't assume that there's no coverage under the GL, general liability policy, or the D&O, directors and officers policy. Now, of course, as you know, in the community association world, there are basically 3 types of insurance policies that we obtain: general liability, directors and officers, and property and casualty. So the general liability policy, this would essentially cover a slip and fall, somebody trips on the sidewalk. Yesterday, I was in Gilbert. My office is in Gilbert. I live in Gilbert. And I was visiting my CPA for last minute tax baloney. Today's tax filing day. It's April 15th, 2025. If you're watching this webinar later than today, April 15th, 2025, I was talking to my CPA, and I walked out after meeting with him for 10 minutes, discussing my extension to file my taxes. And I walked out, and there was a woman lying on the sidewalk. And it was one of those I've fallen and I can't get up kind of scenarios. And a young woman and her 2 children following behind her, a sort of mother duck and her ducklings kind of situation, was walking nearby. And I realized that this woman who was lying there had tripped and fallen. And her adult son, about my age, was yelling at his mother, not kindly. Ma, what's happened? She tripped and fell on the sidewalk. Well, the sidewalk was raised a bit, and frankly, it needed to be ground down. And he came over and lifted her up, and the young mother and her 2 young children, and I sort of helped her with her bags and whatnot. Well, they were looking for a Simon Med imaging place, and I happened to know they were nowhere near it. And I told them that. I said, you need to drive across the parking lot to get to it. And the son, my age basically, dealing with his elderly mother trying to find where to get some image taken, uh, said, "Who's the property manager of this place?" Very upset. And I shrugged my shoulders. I have no idea. I mean, it's just a commercial office area. And started taking videos of the raised sidewalk. Because at this point, he doesn't really know if his mom's okay or not. Could have broken a hip, whatever. And if there were a claim, that's a GL claim for tripping and falling on a raised sidewalk that frankly needed to be ground down. I mean, we know this. This is what happens. So that's a GL policy. D&O is directors and officers insurance for claims for bad decisions by the board, and property and casualty is problems for hail damage to a roof, things like that. So we tender to insurance for coverage when there's a lawsuit. A lawsuit of this type that we're talking about here, failure to pay a vendor would, and we know this, wouldn't be covered by property and casualty insurance. But the fact that I'm so confident of that really makes my point that we shouldn't make any assumptions. Now, it would be weird to tender to a property and casualty policy, but we would tender, but we also know, so we're asking this question, will there be coverage for defense and indemnity? Now, we know under these insurance policies that there are two components of coverage. Defense costs, the attorney's fees to defend under the policy, and indemnity, which is if we lose and there's a judgment entered against the association, the policy pays that resulting judgment. That's what we mean when we say defense and indemnity. The defense is pay the attorneys to defend you along the way. And the indemnity means if we lose and the jury says you owe the other side the money that you didn't pay under the contract, let's say it's 50 grand that you withheld from the vendor, if the insurance company pays that part, that's the indemnity piece. The attorney's fees to defend you in the case along the way is the defense piece. The indemnity is the ultimate judgment where you lose. So we really want coverage for both. And sometimes the attorney's fees along the way is greater than, it's a greater number than the potential indemnity piece. But here's the rub. This is where we run into trouble. Most of these insurance policies that could potentially provide coverage for this failure to pay the vendor lawsuit, which is what this entire PowerPoint slide is about. Most of the policies that could provide coverage, the GL and the D&O policy, have an exclusion for coverage. Coverage is excluded for a contract dispute. So we have a problem. The problem is that when the paint contractor or the landscape contractor says, hey, association, Boca Vista, Green Acre, whatever it is, the hypothetical association here, where you've withheld payment for inadequate quality or failure to perform to the specifications, as justified as that may be, when that failure to pay lawsuit comes back from the vendor and we tender to the carrier, they may very well take the position on insurance company letterhead that there's no coverage for either defense or indemnity because there is an exclusion for coverage for a contract dispute. And if the association were to take that opinion with that denial of coverage letter to an attorney for an opinion about whether the carrier is taking a correct position under the policy, the odds are quite good that the attorney who is consulted on the question of whether or not the carrier is taking a legally correct position on whether or not the insurance policy has a contract dispute exclusion. The chances are quite good that the insurance company is taking a legally correct position. Most GL and D&O policies have a contract dispute exclusion, which means that the association is going to have to pay its own attorney hourly in the litigation from the vendor to essentially defend itself on the failure to pay a lawsuit. So not only is it possible that the association could lose the lawsuit from the vendor, that it does owe the money, but it will have to pay its own attorney's fees to defend itself. So let's assume that it's a $50,000 dispute. I'm just making these numbers up, that the association has withheld $50,000 for inadequate quality and failure to perform to the specifications. Now the association has to pay hourly attorney's fees on the defense side of that lawsuit. And there's no way to know what the limit of that accumulation of hourly attorney's fees is going to be in an attempt to resist paying $50,000. And you know how legal fees are today. There's been tremendous inflation in the hourly rate of legal fees. When I started practicing law in this area in Arizona in the 90s, my first hourly rate was $85 an hour. And if you have any awareness of what current hourly rates are, there's been a lot of inflation. Now, there's been a lot of inflation for a lot of things. The price of eggs, the price of gasoline. It wouldn't take long for us to compare notes of, the last time you remember buying product X for Y dollars or Z dollars, to say, well, you would expect that the hourly rate of attorneys would go up over a similar period of time, but it would be very expensive on an hourly rate basis to avoid paying the $50,000. And there's a good chance you'd lose. I mean, lose something at least. You're going to have to settle at some point with the vendor because the chances that you're going to get out from underneath paying anything in my hypothetical lawsuit here over inadequate quality and failure to perform to the specifications, it's going to be very difficult. Those are tough cases to win. So if we start with the end, we assume a lawsuit from the vendor. One of the things we often look at is, are we in court here? Are we in a mandatory arbitration scenario? Is there mandatory mediation? These are important questions and really kind of points us to more of the discussion today. We started with the end, we started with a lawsuit in court, but there are alternatives that we need to think about as we seek to manage vendor disputes, which really points us back to the negotiation of the relationship with the vendor from the beginning. So we're going to come back to how we can manage these disputes better at the front end through negotiation of the relationship. Let's talk about arbitration for a moment. Arbitration is an agreement. It's a forum where a private judge, an arbitrator, resolves the dispute that's not in court. Often a lawyer who decides the dispute, and it's binding on both parties. Really no way around it. It's called binding arbitration. Mandatory. It's hard to say the words mandatory mediation, but required mediation as a provision in a vendor contract that the parties agree that before going to arbitration will engage in mediation can be quite successful. A mediation in its differentiation from arbitration is a situation where the parties agree that before we get involved in a dispute resolution process like arbitration or court, we will sit down with a facilitative process with a mediator who will put both parties in separate conference rooms, and the mediator will go back and forth and try to resolve the dispute, where the parties will leave if they agree to a resolution where both parties agree to the resolution. I love mediation, where the mediator goes back and forth, called shuttle diplomacy, where the mediator seeks to understand what the problem is, goes from conference room 1 to conference room 2. Sometimes it takes all day. I had a particularly difficult case in the 90s where the mediator spent 13 hours. We ended up resolving it at 11 p.m. at night. And all lawyers have these stories where the mediation takes all day, sometimes into the evening, where the mediator goes back and forth and spends a lot of time with the parties, but eventually turns into a resolution where both sides agree that rather than litigate and spend hundreds of thousands of dollars in legal fees, it's better to choose your own outcome and one that each side can live with. So we started with the end here, this lawsuit that each side should want to avoid, because the vendor wants to avoid this lawsuit as well. They don't really want to sue for their invoices. They just want to be paid. And sometimes they'll take less than the full amount that they're owed just to be done and move on. But there are alternatives to the court system that we need to consider at the front end. Okay, so the vortex of litigation. We call it this because there are no winners in the vortex of litigation. Each side is spending money on legal fees, or there's a lawyer working on contingency. That tends to be a disaster in the commercial litigation context. When I say commercial litigation, I mean litigation that involves businesses rather than personal injury. Lawyers that work on contingency and personal injury tend to do okay. That's why they spend so much money on billboards. Why do they do okay in personal injury? It's a very simple reason. The state of Arizona has enabled the personal injury contingency fee system because the state of Arizona has mandated that every motorist obtain insurance in order to drive a motor vehicle. And it includes liability insurance, so that if I operate a vehicle and I negligently operate it and injure someone else, I have insurance. I have a pot of money that the injured person can recover against. Well, that guarantees that the lawyer representing the injured person can take a contingency fee in representing the injured person and recover against my insurance company. Well, that's pretty amazing. If you're the lawyer working on a contingency fee for that injured person, that lawyer can work on contingency all day long and be confident that there's a pot of money behind me, the negligent operator of the vehicle in this hypothetical. So contingency fee lawyers working on behalf of injured victims in the motor vehicle context have no problem working on contingency, but contingency in commercial litigation is a lot riskier. So how do we avoid the vortex of litigation, which is problematic, especially when it's hourly, given how much hourly rates have gone up? Well, we need to have contract provision diligence, and we need to have contract performance diligence. So I mean, we've got to be diligent about what the contract provisions are. We've got to be negotiating monsters, and we have to be contract performance monitoring monsters. That'll mean monsters in the terrible sense, but we've got to stay on top of this stuff. So what do I mean by provision diligence? Well, what provisions in these contracts are critical? Well, here's the problem with lawyers. We think every provision is critical. Every single freaking provision is critical, or else it wouldn't be there. And sometimes people say, well, that's just boilerplate. No, there is no boilerplate. There is nothing in a contract that's not important. That's what I think. You get to the back end of the contract and there's like all these provisions that seem unimportant. Every single sentence in a contract, every single one of those sections at the end that are unimportant, they're incredibly important. We wouldn't delete any of them. At least I wouldn't. So what's critical? The most important is probably the scope of work. What in the world is the vendor doing? Are they painting everything, or are they just painting the front doors? They're painting the soffits. They're painting the roof tiles. I went on a walk last night with my wife, and we're in our neighborhood there in Gilbert. We're going to get our house painted, and she said, "Hey, if we get our house painted the color that I want, is it going to look funny with our roof tiles being the color that they are?" And I said, "Probably." And then she said, "Well, is it possible to paint roof tiles?" And I thought, well, geez, I've never heard of that, but I'm not trying to chuckle at my wife today, but scope of work. Is the painter going to paint the roof tiles, or are they just painting the parts of the structure that are supposed to be painted? Or are you going to wake up the next day and all of a sudden the roof tiles are painted? So this is critical, of course. How are the payments being made? Is the vendor being paid 100% upfront or based on progress payments? I had a client once that accidentally, I say accidentally, although from the vendor's perspective, it wasn't accidental, paid the entire contract upfront. And then the HOA client was surprised when the vendor left after a week with all the money. It should have been progress payments. The vendor should have been paid 20% of the total after 20% of the progress of the job was done, and then another 20% as 20% of the scope of work was done. But instead, the vendor said, well, I want $300,000 up front. And as we, for the roof project, but for the sake of this discussion, let's assume that there were 5 buildings and it was a $300,000 project. The client gave them all $300,000 up front instead of $60,000 for building 1 and then another $60,000 for building 2, 60 for building 3, 60 for building 4, and then 60 for building 5. It should have been structured off the forms that are given to us by vendors, and this is a perfect example. We cannot just take the form given to us by the vendor. So progress payments, insurance provisions are critical. Indemnity, who's going to defend whom when there's an issue or a problem, and termination. How does the relationship end? If we have ongoing service contracts like landscapers or somebody like that we have an ongoing relationship with. And then ADR, what is that? Alternate dispute resolution. This is resolving disputes in an alternate forum like arbitration, mediation, steps toward dispute resolution that might not involve going to court. And then boilerplate provisions like choice of law. I've seen many vendor contracts where the vendor might have a home office in Minneapolis, Minnesota, and the choice of law says disputes are going to be resolved according to law of Minnesota. And the forum for disputes is Hennepin County, Minnesota. essentially, if there's a dispute, the lawsuit has to be filed in the courthouse in Hennepin County, Minnesota. We don't want that. We're in Maricopa County, Arizona, and we don't want to resolve this according to Minnesota law. Um, but we've got to have contract provision diligence and awareness. If a company is going to come out to Arizona and do business here, we need to have disputes resolved according to Arizona law, and we don't need a choice of forum for disputes to be in some far-flung place like Orlando, Florida, or Tallahassee, Florida, or Nashville, Tennessee. That's not fair for associations in Arizona to be expected to resolve disputes according to the law of another state, or to resolve disputes in a court in another state. We're sticklers for that. But if you sign the contract as presented by the vendor, then those provisions are going to become important and expensive later. And we've got to have provision diligence. And then when it comes to performance diligence, we've got to have this critical thinking about, are you getting what you're paying for? If not, we ask ourselves the question, to what degree? Is it a terminate and move on situation, or is it to a degree that we need to sue over it? Small deviations, maybe we terminate and move on. I've seen this many times where most board members understand the calculation. If we've just reached to a point in the relationship where we're just not getting along, business divorce makes sense. The mowing of the grass, it's just not looking right, but it's not costing us anything. It's an aesthetic problem. Let's just terminate and move on and find somebody who can do a better job. That's not hard to comprehend. If it's a big deviation where the contract required that the mowing occur every week, but it's been once a month, do we sue over that? Probably not, because the new company can do it every week. But has that cost us anything? Mowing once a month versus every week, it's hard to quantify that. A judge is going to look at me in the courtroom, and in lawyering, there's very few things that are more unpleasant than explaining a case to a judge and having a judge raise an eyebrow and move his or her hand and essentially raise the eyebrow and say, "That's your case?" Question mark attitude. And followed up with the question, "But Mr. Carpenter, your client can start mowing every week now. Where's the harm? How do you quantify in dollars today the cost to your association, the harm to your association client for the fact that in the past the grass wasn't mowed every week?" And if I have to stand in the courtroom and wonder for even a moment how I'm going to explain that, then I've got a serious problem. But I can anticipate that in advance. So there's no big deviation in this hypothetical to the fact that the landscape vendor didn't mow every week. That's not a big deviation. There's also a challenge of contingency fee, legal fee arrangements, which I mentioned earlier. Let's go through the math real quickly. Let's assume that there's a deviation in a contract performance of $100,000, and the board wants the lawyer to partner in the dispute. That means on a 1/3 contingency, let's just create a 33% contingency fee for the lawyer. The lawyer's very best day is $33,333.33 in legal fees. Let's assume that the lawyer calculates that her time is worth a $333 hourly rate. That's the internal calculation that the lawyer goes through to figure out whether to undertake a contingency fee. The lawyer has to go to trial and collect in 100 hours of effort. That's pre-litigation investigation, pre-litigation demand letters, file the lawsuit, do discovery, that's depositions, demand for records, and all of the other discovery activity, go to trial and collect in 100 hours of lawyer effort. I said billable effort, I meant lawyer effort. Now, $333 attorney effort rate may or may not be the number. And this reminds me of the summer job I had during college, where I was trying to accumulate enough cash to buy my wife an engagement ring. I worked for a painter. Um, One of the most fun jobs I've ever had. No, I love being a lawyer, but I enjoyed my time as a painter. And I asked the guy I worked for, how do you bid a job? And he said, well, I think about how long it might take. And and this was 1980, whatever. Doesn't matter at this point. And he said, I think about how long it's going to take, and I basically multiply it by $30 an hour. And that resonated with me. Just sort of made sense, that you've got to have a multiplier and you have to imagine how long something's going to take. And that's essentially what's going on here. It's the same thing that goes on with job bidding in really any context, whether it's a painter doing residential painting in Dallas, Texas in 1980, whatever, or if it's a lawyer looking at a case like this and saying, well, I'll partner in the deal, but I've got to imagine that for a 1/3 participation in a $100,000 dispute on my very best day, I have to get it done in less than 100 hours of attorney effort. It doesn't pencil out for the lawyer unless the lawyer can build enough fear in the vendor and the vendor's attorney that it can be settled and resolved in less than 100 hours of attorney effort. But if it's settled, the vendor's never going to pay the full 100. If it's settled for far less than the vendor's worst case scenario. So in this scenario here, where I say the deviation is 100, that's the vendor's worst case scenario, which is also called the association's very best day. Well, if it's settled for 30,000, then the lawyer's very best day at 30,000 is 10,000. I mean, the lawyer's best day is 10,000, not 33,000. I would never take the case. Would never take the case. And there aren't very many community association lawyers that I know in the Arizona Community Association bar. The group of us that do this, including my former firm, that are chomping at the bit to undertake these cases on a contingency. They're incredibly difficult. And so what ends up happening is they're essentially hourly cases. And the math that causes the lawyer to say, I don't want to partner in the dispute, is the same math where the board says, are we going to spend 50 grand in attorney's fees to chase 100 grand? Well, that math doesn't math very well for the association, because there's no guarantee that it would only be 50,000 for the association. Why would the association spend 50,000 or 100,000 to chase 100,000? And there's no guarantee that the association will win $100,000 at the end of this commercial litigation dispute. Is the jury going to buy it? Can we prove every bit of this $100,000 claim? Are we going to get our very best day? And if we go to mediation, voluntary mediation, where this skilled lawyer, ex-Superior Court judge shuttles back and forth in shuttle diplomacy, if the association has spent $75,000 in legal fees to try to recover $100,000, what's the settlement position? Is the vendor going to pay $175,000, $100,000 for the dispute and $75,000 in legal fees? Or are they going to pay $50,000 total or $25,000 total and say each side walk away paying your own attorney's fees and costs? That kind of stuff happens all the time. So it's a mess. And for those of us who have handled these kinds of cases for years, we know that either way you do it, with the lawyer partnering in the dispute or with the association paying the legal fees, these kinds of cases are a litigation vortex where the winners are the lawyers on an hourly rate basis, and on a contingency fee basis, the lawyers looking at a black hole of time wasted that never really gets compensated, and a bad result for everybody. So it's bad news. It's bad news all around on the litigation side. So let's talk about drafting diligence. We were talking about um, provision diligence, performance diligence, and let's get to another form of diligence here, which is on the drafting side. 99.9% of vendor contracts are created by the vendor. And in many cases, as you all know, the association signs the contract as presented. There is very little negotiation, and there's this sense that that's just the way it is. It's kind of like going to the store and buying something. The price is the price. We don't negotiate in America. We don't negotiate the price in a store. Some cultures do. We don't in America, and so it's fun to be tourists sometimes and go to a foreign country and negotiate with vendors and stores. I don't so much like it, but some people do. My dad loves that kind of stuff, and I've been with him when he's done it, and I don't think he's particularly good at it, but he thinks he is, and he loves it. But this is what happens here in America. Vendors say, here's our contract, and clients, associations, sign it as presented, but it's created by the vendor. So it would be no surprise then that these contracts are not friendly to the association. I put it here as a question mark. Are they friendly to the association? No, they're not. I'll say it a different way. No, they are freaking not friendly to the association. If they are 99.9% created by the vendor, of course they're friendly to the vendor in every way. From the scope of work articulation to the insurance, to the indemnity, to the termination provision, of course it's friendly to the vendor. If I were the attorney for the vendor, I would draft it to be friendly to the vendor. Of course I would. In fact, that would be my job. That would be my duty as the lawyer for the vendor to draft it to be friendly to the vendor. Absolutely, it would be my legal duty. So one thing that we've done for a few clients over the years is to deal with this problem is we've created a standard vendor contract addendum. No matter what the vendor drafts, we slap on an addendum. In that addendum, do we want ADR? Do we want mandatory notice of a claim, mandatory face-to-face negotiation as a precursor to mandatory mediation as a step before arbitration? Yeah, I would. Should we want our own insurance and indemnity provisions? Should we want our own clear statement on termination in a service contract, such as ongoing landscape maintenance, pool maintenance, or other maintenance contract? Yes. Yes to all three, in my view. Here's what we don't want. We don't want to over lawyer every vendor contract. I don't want to work against myself and keep talking about high hourly rates for lawyers, but we don't want to over lawyer every vendor contract. But there is a cost benefit equation for small vendor contracts, obviously. Legal fees and reasonableness at the outset becomes an issue. But unfortunately, sometimes the better measure is termination and litigation for bad performance after the fact. It's this looking back question. But hindsight's 2020, and we don't know. We don't know until there's litigation for bad performance, and there's no way to know. And so we end up in a situation where, when we're in the vortex of litigation and the association is spending thousands of dollars every month, and in litigation, sometimes the legal fees are in increments of $10,000 a month. And we look back and say, well, if we had just spent $1,000 on contract drafting diligence, we wouldn't be in this litigation. That's a terrible feeling. So under this broad bullet point of over lawyering every vendor contract, we have 3 observations. Hourly legal fees make vendor review of every contract problematic, the cost benefit analysis, and then when there's a problem and there's litigation, we would look back and say, well, I wish we had had some contract review. And that's where we get stuck in. When things go horribly wrong and we're in the vortex of litigation, we would have wished we had spent a little bit of time and energy and money on contract drafting diligence. And that's why some associations have moved to this standard addendum situation where the vendor sends over their POC, vendor contract, piece of crap, excuse the language, and the association slaps on its standard addendum, and either the vendor accepts the standard addendum or it forces a conversation about the POC nature of their vendor contract, and maybe the vendor revises some of their provisions that conflict with the addendum, because either the addendum becomes a default suggested red line of their vendor contract or the vendor accepts the addendum. So there is room for the addendum to spark a conversation about the nature of the vendor contract on ADR, insurance and indemnity, and termination, or the vendor accepts the addendum, and then we're good to go without having to over lawyer every vendor contract. And that's why we've had so many clients over the years adopt the standard addendum format, because it is friendly to the association, but also can have the effect of negotiating the vendor contract's terms without having to end up in a confrontational posture, even though the vendor doesn't really want to, they say they don't want to negotiate their contract. So drafting diligence is something that we tend to focus on. All right. Any questions about anything I've said? I kind of covered a lot in a quick time period there. We use the webinar question format. If not, that's cool. Chat feature. Seeing none, motion to adjourn. All right, thank you all for participating today. Hopefully you've enjoyed this. Vendor contracts and vendor disputes are always a hot topic. I will see you all next month, and we'll keep an eye on the legislature and our July 15th webinar. Look forward to that as always. Thank you.